In this installment of Washington Legal Foundation's Legally Brief, we are joined by Cadwalader, Wickersham, and Taft partner Bruce Heiler. Bruce, at the end of last December, the Securities and Exchange Commission entered into its first non-prosecution agreement with an enforcement target, children's apparel company Carter's, in a situation where the SEC is still pursuing charges against the Carter's executive for accounting fraud. Briefly, what does the NPA require of Carter's?
Well, the NPA, it's really a rather brief document. There are 4 pages that contain provisions, and there are really only a couple of provisions that I think impose any sort of substantive burden of any degree on Carter's. The first is really the core of the agreement, which is the Commission agreeing not to bring an enforcement action against Carter's. In return for that, Carter's agrees to cooperate, and the cooperation is worded as, quote, fully, truthfully, and continuously, end quote. And then there's several other paragraphs which explain that further, and that involves, of course, production of all non-privileged documents. And I think that's an important point. There is no explicit waiver of privilege, and in the provision talking about production of documents, it specifically says only non-privileged documents. And they have to, Carter has to use its best efforts to have all of its former and current officers, directors, and employees cooperate. So using best efforts in that situation as opposed to guaranteeing it. That's somewhat of a usual provision. There's an unusual provision, in my view, that's added to that, which is cooperation with any other federal, state, or self-regulatory organization. The only other provision that's really, I think, substantive and potentially burdensome is that Carter pledges that if it were to sell substantially all of its assets or transfer substantially all of its assets or its business operations, that it would include a clause in what the operative agreement binding the successor to the NPA. All the other provisions are pretty much formalistic or procedural, and you see them in many other SEC settlements, such as prohibition against denying any of the underlying factual matters.
Do you think that any of the stated obligations that Carter's must conform to are rather broad, including the one that you had mentioned a second ago?
I think these 2 substantive provisions that I mentioned are quite broad, and there's some ambiguity, in fact. Now, the first part of the cooperation provision, which is cooperating with the SEC, is limited to cooperating in the instant investigation, the investigation that led to the NPA, as well as to related proceedings. And of course, as you mentioned, they are continuing to litigate with a senior executive from Carter's, a former executive. That type of cooperation is common in any settlement where the SEC continues its investigation or continues litigation, and it's limited to those particular situations, the litigation, related litigation and the investigation. However, the provision for cooperating with other federal, state, and self-regulatory organizations is triggered if the Division of Enforcement actually simply asks Carter's to cooperate with another agency, and it is unbounded. There is no time limit on it. Now, maybe it's just a matter of drafting, but 5 years from now, conceivably, the way it's written, another agency could ask for Carter's cooperation. I would assume that the Commission would interpret that reasonably and would not interpret it as a perpetual pledge of cooperation. But those provisions can be quite broad. One other provision I think worth mentioning is that the judgment as to whether Carter's is complying with the cooperation requirements is left solely to the discretion of the Division of Enforcement. And so you're pretty much in the mercy of the Division of Enforcement on that. On the other hand, implicit in the process of the Commission, there's some limit on that, because if the Division of Enforcement wanted to tear up the NPA and recommend an action against Carter's, they'd have to explain that conduct to the Commission and would have to explain to them why they felt Carter's wasn't cooperating. So there's at least some review of those judgments.
Does this particular NPA, given that it's the first one, give any kind of indication as to when the SEC will simply decide not to pursue enforcement versus utilizing these kind of NPAs?
No, it really doesn't. I mean, actually, one of the beauties of the NPA is it does not contain any factual allegations. It does not express a view of the Commission or the staff as to what Carter's or its employees did or did not do. You have to look elsewhere for that. So looking at the press release that accompanied it, and looking at the complaint that accompanied it also, in which the former officer is sued, what you see is, on the one hand, the official seems to be fairly senior, It's alleged that he was the executive vice president of sales and that all the vice presidents of sales reported to him. It's alleged that he reported directly to the president. That's a fairly senior position in a company. Secondly, the conduct which he was alleged to have engaged in seems to go to the core business of Carter's. The conduct involved allegedly giving unauthorized discounts on the sale of Carter's products to, in fact, its largest wholesale customer. So when I looked at those things and a couple of other matters in the complaint, I thought that this was probably the type of action or situation in which the Commission would have at least brought a cease and desist action against Carter's. You can't tell for sure. And then I read further. And in fact, when the SEC brought this action and brought the NPA, the Division of Enforcement staff people indicated in the press release that they felt the conduct was isolated. So they viewed this as isolated conduct, presumably isolated to this individual and maybe one of his assistants. And then I read further. The complaint actually alleges that the former officer lied to people at Carter's to cover up his conduct and had one of his assistants falsify documents. So with that picture, the company sort of becomes a victim, and I would at least hope that the Commission in that sort of case would strongly consider not bringing any action, even an NPA, where the company may be as much a victim as anything.
And finally, what can public companies take away from this first NPA in terms of implications?
Yeah, it's a good development. It's a development I think people have waited for, something other than an action that has sanctions in it. And the NPA has no sanctions. There are no findings of fact, as there would be in a cease and desist action. You're not under a federal court injunction. There's no view given by the Commission in the body of the NPA as to whether you were good, bad, or indifferent. So those are positive things, and especially because sanctions in SEC proceedings can often result in collateral implications. You can be disabled from utilizing, for example, the safe harbor for forward-looking statements, or disabled from using certain small offering exemptions and so forth. So it's a good development, but you also have to realize, I think, that even an NPA can have collateral effects. There's nothing said in the NPA, so the public is left to guess. And therefore, I think it's important for people entering into those, individuals or entities, to try to find out as much as they can about what might be said in a related proceeding that the Commission may be bringing. Now, the Commission staff isn't used to and doesn't, as a matter of course, give you access to that and won't negotiate someone else's papers, especially papers which they're going to litigate. But you may be able to find out something, and I think that's important because this document then that is out there making allegations against the Carter's executive, if it had contained adverse allegations as to Carter, that could have affected it, at least from a psychological standpoint and a strategic standpoint, in terms of how a judge or private plaintiffs might view that in private litigation. And the final thing I would take away is obviously this is something where the Commission is trying to encourage cooperation, encourage companies not just to remedy situations, but to monitor and to discover those situations quickly. I think that's great. I hope that they won't be used just in cases where the company was the first one to discover it. That did happen in Carter's. They found the conduct, brought it to the Commission's attention. But especially with the new Dodd-Frank whistleblower provisions, I'm not sure that the company is going to have the opportunity often to be the first one to discover it. So I hope it's not limited to those situations. I would also say I don't think cooperation means capitulation. I've never viewed it that way. Indeed, I think Carter's probably presented to the Commission its view on why it was deserving of a NPA. So I think when you do get in these situations, you want to monitor, you want to remedy the situation quickly, and you want to remedy it fully. But you also have to make your case as to why you think the situation deserves leniency.